Hello and welcome to this talk about bringing a claim for judicial review. My name's Declan O'Dempsey, I'm a barrister at Cloisters Chambers, and in this talk I want to deal with the acknowledgement of service and with the process of obtaining permission to proceed with your claim for judicial review. At the start of the claim, you must serve, that is send, a copy of the claim form which has got the administrative court officer's seal, the court seal. You send this to the defendant and everybody else in the case, and you must do that within 7 days of lodging the claim with the court. Within that same 7 days, you should serve a copy of the bundle of documents that you filed alongside the claim form. In Annex 3 to the guidance on bringing a judicial review claim issued by the administrative court, you'll see the addresses of the government departments, and you can serve these documents at those addresses if you're against one of those government departments. On the other hand, if you're against a local authority, for example, you serve these documents at the local authority's main office, but you must include a note that the papers are to be directed to the local authority's legal department. When you've served, what do you do next? Well, you have to confirm that you've served with the court office. You do this using a specific form, Form N215, which is a certificate of service. You file that with the court office, and you must do that within 21 days of service of the claim form on the others in the case. If you don't file the Form N215 within 28 days of the service of the claim form, and if the court office doesn't receive an acknowledgement of service from the others in the case, then the court office closes the case. At that point, you can only get it reopened by order of a judge, and you have to make an application for that. You'll have to pay the fee for making an application, and you'll need to explain why the form wasn't filed within the 21 days given. You'll need to explain if any prejudice has been caused to others in the case, or if there's been any delay in the proceedings. And you'll need to outline why, nonetheless, your claim should be reopened. So I mentioned the acknowledgement of service. This is something that the others in the case, the defendant, for example, will need to fill out. If the defendant's interested in participating in the application for permission by you, then the defendant must file and serve the acknowledgement of service using Form N462. If the defendant doesn't do that within the time allowed, it means that the defendant's point of view is not considered by the judge deciding whether or not to grant you permission to proceed with your claim. Secondly, if you have to renew your application for permission at a live hearing before the judge, the defendant can't participate in that hearing unless the judge allows them to. Third, the judge hearing any full judicial review hearing can consider the defendant's failure to file the acknowledgement of service when considering who should pay the costs and how much those costs should be. You should note, however, that the defendant can participate at the final hearing if you're given permission to proceed, even if the defendant didn't file the acknowledgement of service. So the time for filing and serving the acknowledgement of service is the 21 days within 21 days of the claim papers being served on the defendant. Now, that time limit can only be extended by the court, and then no later than 7 days after the documents filed with the court office, the acknowledgement of service should be served on you. So what happens after that time limit has gone past? Well, as soon as the acknowledgement of service is received by the court office, or if the end of the period for filing passes and nothing was received, then the court office gives the papers to a judge who considers the documents and decides whether, on the basis of those documents alone, you should be allowed to proceed with your case. This is known as the consideration on the papers, or a paper consideration. You can write a reply to the acknowledgement of service if you want to, and if it's received before the papers are sent to the judge, then the court office includes that reply. But the court office doesn't have to wait for a reply, and the judge, even if there is one, doesn't have to consider it. What can you expect to see in an acknowledgement of service? Well, the important part of it is that it should contain the summary grounds for the defendant contesting your claim. It should be as concise as possible, but it should contain the summary grounds of the defence. You'll find the summary grounds of defence in section C of the document. However, you may find that the defendant's decided to attach a separate document. There's nothing wrong with that, but nonetheless the grounds should be summary ones and should be concise. If the defendant is going to counter your application for permission to proceed by saying that it's highly likely that the outcome for you wouldn't have been substantially different if the conduct about which you're complaining hadn't occurred, then the defendant must say this in the acknowledgement of service. And you should be able to see in section A that there's an appropriate box which the defendant can tick. So if it's ticked, it means that the defendant will use this argument. However, the defendant must also set out the summary grounds for making the argument. Section B of the Acknowledgement of Service can indicate anyone who the defendant thinks may be an interested party in your claim, and the Acknowledgement of Service can also seek orders, such as the order that you should pay the costs of the defendant preparing the Acknowledgement of Service, or, for example, the discharge of an injunction order if you obtained an injunction at an earlier stage of the proceedings. So you might see that sort of thing. You'll see these things set out at section D, but once again there may be a separate document consolidating those points. So, when does the court grant permission to proceed? What you're trying to show in your application and your grounds for permission to proceed is that you have an arguable ground for judicial review which has a realistic prospect of success. And what you've got to be able to show is either that the decision or omission to make a decision was illegal, procedurally unfair, or irrational, primarily in the sense that it's a decision which no reasonable decision maker could reach. However, even if you can show that, that may not be enough, because you've also got to be able to show that it's an arguable error which might make a difference to the outcome. So, the judge has to refuse permission, even if your case is arguable, if the judge thinks that the outcome for you wouldn't have been substantially different if the conduct complained of had not occurred. So your application for permission should concentrate on both of those aspects. Say why the decision's wrong, and say what difference that error made to the outcome for you. What you get back after a paper consideration has taken place will be an order of the court. Now, this may say one of several things which we'll examine over the next couple of slides. First, that permission has been granted. Well, that means you're taking the case further. What you should look for is to see what directions, those are procedural orders, the judge has given. You'll need to comply with them, so write down the timetable that you have to observe. Put it on your calendar. Work towards complying with the deadlines, and you should do this ideally several days before the final compliance date. The other order that you might see is permission is refused. This means nothing is going further. There are various things you can do about this, and we'll look at those later. Have a look at the judge's reasons and look to see if there's an order that you must pay the defendant's costs of the preparation of the Acknowledgement of Service. Next, you might get permission granted for some things but not others, so the order would be permission granted in part. The judge says you can continue with some of your grounds. Now, in this situation, you can ask for an oral hearing, a renewed hearing, if you want the court to reconsider the grounds where permission has been refused. Other orders that you may get will include permission adjourned to an oral hearing. So this means that your application for permission to proceed has been adjourned, no decision has been made. There will be an oral hearing at which the defendant and you can make representations on whether or not permission should be granted. You should remember, if you've got one of those, that you make representations first. Next, there could be an order for what's known as a rolled-up hearing. This means that the permission hearing and the full hearing are put into the same hearing slot, and the court will decide whether you should get permission and then go on to deal with the merits of the case. So in practice that means that the court will receive all of your arguments about whether you've got an arguable case and the substance of the case all at the same time. So technically it decides first whether you've got an arguable case and therefore whether you should get permission, and then goes on to consider whether your case should win at the final hearing. Normally the court doesn't decide those separately, but it makes a decision on the merits of your case compared with the defendant's case and whether to grant you permission at the same time. Now, if this is the order that's made, then the court office will ask you to sign an undertaking to pay the fee for the full hearing, and you will do that as soon as you are granted, if you are granted, permission to proceed to the full hearing. But of course, since that happens on the same day, the court likes to have an undertaking from you that you will pay the full hearing fee. Something else that you may see on the decision on the papers is that your claim has been certified as being totally without merit. Now, if your case is refused permission, the judge may certify it as being totally without merit. What this means is that the judge considers that it is bound to fail. It's important to remember that this does not necessarily mean that the claim is abusive or vexatious. But if this certification is given, and it's usually just an endorsement on the papers, then there's no right to a renewed oral hearing, which you would otherwise have. The claim finishes in the administrative court subject to your right to appeal. Suppose then that on the papers you've been refused permission to proceed with your claim. You should consider the judge's reasons carefully, which will be given in brief on the papers that are sent to you. 7 days after the refusal, the court office will close the case if nothing happens, unless costs are being sought by the defendant, for example. You can, during that time, request that the application for permission to apply for judicial review should be reconsidered at an oral hearing. The court office will have served on you the order refusing permission, but it will also have served on you a renewal notice, which is Form 86B, so that within 7 days of the date on which that's served on you, you can complete the form, return it to the court office and to everybody else in the case. Note this, however, you must give reasons for renewing your application, and these must address the judge's reasons for refusing you permission. So you must briefly explain why those reasons are wrong. Now, this doesn't mean that you simply reassert your original points. If you fail to engage with the reasons given by the judge, then sanctions may be imposed on you, and these can include cost sanctions, but there may be other sanctions which the judge may think appropriate in your particular case. So, for example, you might succeed but not get your costs for a particular part of the hearing. If you've managed to get your application in on time and you've engaged with the reasons of the judge, then a hearing is held to consider if your case is arguable. Now, you will get about 2 working days notice of that hearing, so don't wait until then to be drawing up your arguments for that hearing. Prepare early and you will be able to refine your arguments nearer the time. You must remember that these hearings are very short, as we'll see in a minute, so make your best points, and make those best points very briefly. You get 30 minutes, including the time given for the judge to give judgment, and that's going to be between 5 and 10 minutes. That's the normal time allocation that's given to one of these renewal applications. If you think you're going to need longer, then inform the court office as soon as possible and before the case is listed for hearing. If, in fact, you need longer and you discover this on the day, this may actually result in the case being adjourned, and in which case you might face a cost sanction if it's your fault. For example, if the defendant has been asked to attend and it has to be adjourned, you may end up paying their adjournment costs, so the costs of them having to turn up on that day. It's very rare for longer than 2 hours being granted for one of these hearings, and the court will give you what time it thinks appropriate. It will make a prediction how long your sort of case should take, and it will have regard to the reasons you've given for needing more than 30 minutes. And remember, the time allocation includes the time for delivery of judgment by the judge. So, what happens at the hearing itself? First of all, it's in open court, and that means anyone can attend and listen. Don't be put off by people who you don't know appearing at the back of the court. They may simply be coming in to have a look at what one of these sorts of cases is like. Anybody else in the case can attend, but they don't have to unless the court says that they must. If somebody who's involved in the case does attend, then you should ask yourself whether they filed an acknowledgement of service. If not, they've got no right to be heard unless the judge gives them permission to be heard, and they would have to apply for that. Do bear in mind that the court is trying to get through business efficiently, so when you're given a time to attend at court, you may be asked to wait until a later time in the day. So let's turn to what happens once you're in the courtroom. You address the judge as my lord or my lady, and how the case proceeds is really up to the judge. But in general, you're going to be the one who speaks first. It would be sensible to summarise in very short terms the grounds that you're relying on. So you might say something like, my lady, ground 1 is where I say that the decision was unlawful. Ground 2 is where I say that the decision was not reached following the rules of natural justice. And then you turn to each of the grounds, and you might say something like, in relation to ground 1, my lady, the decision was unlawful for the following, and you say however many there are, number of reasons. So what you're doing is explaining why you contend your grounds are arguable. The defendant speaks second, and the defendant will set out why the grounds are, in their opinion, not arguable, or give other reasons why permission shouldn't be granted. So at this point they might raise delay, or they might say that any flaw in the process or decision made no difference to the decision in relation to you. Interveners and others may get the chance to make representations as well. Now, one of the difficult things that you'll need to do if you're representing yourself is to listen to what's being said, make notes of it, and get ready to reply. So a sensible thing to do is to make notes in one colour, and then just have a pen of a different colour to underline or make a mark next to the parts that you want to come back at. This is because you're usually given a right to a short reply, and you need to be ready to be brief. If you've been making notes, it'll be easy for you to use the defendant's structure, and you might say something like, as to the defendant's first reason, my lady, I say this. But do remember, you need to be brief. The judge can ask questions at any point, so be prepared for it, and don't take them as an attack on your position. They aren't necessarily. The judge may well be trying to understand your case and why it might be arguable. And it may well be that there are points that you do need to answer and which are difficult for your case. So respond courteously and briefly to the judge. So at the end of the hearing, the judge will say what his or her decision is and whether they're refusing or granting permission. And remember, that's supposed to take place within the 30 minutes allocated to the hearing. At that stage, the judge may, if appropriate, give further procedural orders or directions or other orders. That's the point at which they'll be announced. So when the judge is speaking and giving his or her reasons, keep a note of them. It's difficult to do this, but focus on getting what is being said down on paper. And if you've got a laptop and can touch type, for example, you may be able to keep a note using that. After the renewal stage, well, if permission is refused, that's the end of the case in the administrative court, and the only avenue you have will be to appeal. If permission is granted, the case proceeds to a full hearing at a future date, unless the court had indicated that it was going to go straight in to hearing the full merits hearing.